Welcome back to the Law and Crime Trial Network. I'm Stacey Delikat. We've just been watching live closing arguments in a Kansas courtroom where Yesenia Sesmas is on trial for murdering a woman and then stealing that woman's baby Sophia. Again, we just heard closing arguments. The prosecution saying this was premeditated, that Yesenia Sesmas planned out this murder for weeks, they allege, because she had been pregnant and had a miscarriage. She did not want to tell her friends, her family, her boyfriend she'd had a miscarriage. Instead, planned to steal the victim, Laura Abarca's baby, and take it home, show it off as her own. Defense trying to prove that this was just a reckless murder. It was unintentional and accidental. I'm joined via Skype by Gary Gerstenfield, criminal defense attorney, who is down in Maryland. So, Gary, I have to ask you, if you were a juror in that courtroom, what do you think after hearing those closings?
I was actually impressed by the closing by defense counsel, because this is a very, very challenging case. As he acknowledged, the evidence of a homicide is undeniable. The question really is whether or not this is a first-degree murder, or can you get something less than that, a second-degree murder, or something even less than that would be some sort of a recklessness. The question is, did he move the ball forward enough? In the end, probably not. It was a very short closing, and what he did basically was try to give teasers to the jury for them to think about. Sometimes you do that. You present arguments to the jury and then hope that when they go into the jury room to deliberate, they start to create their own scenarios and hope that that sort of takes on its own life. And then you're able to get the jury to start questioning what is arguably a fairly simple case.
Yeah, the defense attorney said this was not a planned, premeditated murder. It was something far more random and chaotic. It was unplanned and spontaneous. Now, whether or not the jurors will buy that, we don't know. But to your point, yes, he did really try to lay out some of the other charges they could arrive at, including, of course, involuntary manslaughter. Gary, the fact that the defense did not put up any witnesses, did not basically put on a case, does that factor into the jurors, in your opinion?
It's not helpful, but he's stuck. He certainly can't put Yesenia on the stand because, number one, he has no control over her whatsoever. And when you put a witness on the stand, you know that they're going to be impeached by prior inconsistent statements. Remember, she was questioned by the police. There was an interrogation. She gives inconsistent statements. And there's a lot of questions that she would be able to answer if she were put on the stand, that now defense counsel says, look, the prosecutor didn't prove to you that there was the absence of a fight or that this was premeditated because we don't have all the information. Well, the reason why is because, of course, the victim is dead and, Yesenia chose not to testify. If she took the stand to testify, then I think it would have been a much easier argument for the prosecutor to make, is now we've dotted the I's and crossed the T's in terms of proving what she was thinking at the time of the murder. This is a question that the jury will have to, at some level, and I think the defense counsel is correct, will have to speculate on. But there's a lot of good information here that they have to use as milestones to determine whether or not this is a premeditated first-degree murder case.
What do you think of the defense's argument? If she really meant to kill Laura Abarca, she would not have driven there in a car that was hers and left in a car that was hers and allowed herself to be seen on surveillance video. She wouldn't have left this cartridge behind. She wouldn't have tried to obscure her identity at any time or cover this up more. What do you make of that?
Well, I think it's some good points, but poor planning is not the equivalent of lack of planning. And so there's three things that the prosecutor made in his closing argument. So let's look at that very quickly. We have conduct before the homicide, we have conduct during the homicide, and then we can look at conduct after the homicide. So let's start with before the homicide. We have on November 16th, Yesenia showing up at the house, asking some very intriguing questions about the security, whether people are around, and other questions that show that she's doing some kind of planning. Then we have November 17th. She shows up with a gun. She shows up in the house. What we see is we don't see evidence of any kind of a fight or disturbance. As a matter of fact, it looks like the shooting took place at extremely close range, and there doesn't look like any defensive efforts on the part of the victim, Laura, which suggests that this was something that she was not prepared for. Again, the absence of any kind of altercation or any kind of a fight, and the lack of any struggle. And then, of course, conduct after the homicide. It's sort of a Camus argument, which is that, consciousness of guilt suggests the person really intended to do what they did. We have several things there. We have lies, of course, that are told throughout the process. We have lies to other people with pictures that are taken that are not accurate, stories that are not accurate. And of course, when she's questioned by police, she gives conflicting stories. And the selfie, the picture of the selfie showing that she's very, calm and happy, and there's no residual effect or impact of having just been involved in a murder case.
Right.
That kind of collectively, those three things, I think, are going to be very powerful for the jury.
Yeah, and the prosecutor, talking about text messages that she had sent back and forth to her friends, this sort of web of lies she had spun, the lies you were referencing. She had sent her aunt and other friends pictures of baby Sophia, cropping out the baby's mother, Laura Abarca, and father, trying to send these photos as her own. And the prosecutor basically saying he believes those text messages are evidence enough that this was a premeditated murder. One other thing I wanted to ask you about, the defense sort of threw in the part that the defendant, Yesenia Sesmas, feared her boyfriend would physically hurt her, perhaps if she had lost the baby, that she was in fear of her own safety. No, of course, coincidence that he mentioned that, but do you think that jurors will consider that at all, that this woman is really so terrified to tell her own boyfriend or that she had had a miscarriage that she had to go to these lengths?
Well, boy, that's a lot of that's a long walk around the park trying to come up with that as a defense argument. There is law that the idea that somebody can be forced to commit a crime under ordeal, and there'd be some defense to that, but that does not include murder. And but for example, if I'm holding your child, not you, but if I'm holding a person's child, for example, hostage, I say you got to go to the first bank and rob the bank. Because if you don't, I'm going to kill the child. That is actually a defense in the law, but if you shoot and kill somebody in the process of the bank robbery, that's not going to be a defense. So will that move the ball forward? No.
Gary, let's go back live into the courtroom now where the rebuttal has begun. Welcome back to Law and Crime. I'm Stacey Delikat. If you're just joining us, we just saw Yesenia Sesmas led out of a Kansas courtroom. The judge has sent the jury to deliberate on murder charges against her. I'm joined by Gary Gerstenfield, criminal defense attorney. He's in Maryland, joining us today via Skype. Gary, we just heard the closing arguments. We heard the rebuttal to the closing arguments. I want to touch on one of the first things the prosecution said, brought up again in their rebuttal, which was would the victim in this case, Laura Abarca, what evidence is there that she actually intended to give up her baby to the defendant, Yesenia Sesmas? She had been sending pictures after the baby was born to friends and family of her and her fiance with the baby. Both her mother and fiance testified that she was so excited to become a mother, so excited to raise this child. Assuming there are parents on the jury, which I imagine there may be, or grandparents, whatever it is, do you think it will be, do you think it will be hard for them to believe this defense theory that the victim agreed to give her baby up to this woman?
Well, it's great to be with you, Stacey, and the listeners and people who've also been watching this trial on the channel. Clearly that's going to be a failure. If there's one thing that the prosecutor had no trouble whatsoever establishing, is that this was very much a wanted child. And a love child. And I suppose it's not so much a criticism of the way the prosecution tried the case. I think they did a very good job. They definitely dotted all their I's and they crossed their T's. It was well prepared. They put their witnesses on, and the witnesses led the trial in exactly the direction that I think the prosecutor was looking for. But I would say that in the closing, this would be an opportunity to give voice to the anguish and the pain that the family is suffering. This was a very dry close for the prosecution, and I suppose that because the case is so strong, they did approach it with a very sort of methodical way. But I would say that given the facts of this case and the horror of what happened, it seemed that some passion probably would have been appropriate in the case, at least at the time of closure.
Yeah, I mean, that's a good point. This baby girl, baby Sophia, is no longer a baby. She's a toddler now, 1.5. You know, it's hard once you think about this. Wow, this child was ripped away from her mother at just 6 days old. The victim of this abduction, you know, sort of what impact that will have on her life as she grows up and those around her. So that's a good point. In the rebuttal,
yeah, there's three pictures. There's three pictures in this trial that are very compelling and very troubling. You have the picture of the baby with her mother, and it's a very powerful picture. You know, I mean, of course, a newborn child being held by its mom. It's a very warm and beautiful picture. You then have this horrible picture of Laura literally lying there peacefully with a bullet in her head. And that's a powerful picture. It is, in fact, when you've shown that, you've had to warn viewers of the nature of the picture and the fact that it's unsettling. And then you have the third picture, which is the selfie that Yesenia took of herself the day after. She looks quite happy and content. You take those three pictures, you put them together, and I think that that's such a powerful image. And I think that again, you don't want to necessarily impassion a jury so that they sort of run out and sort of do a lynch mob mentality. By that same token, though, you do need to, I think, at some point encourage the jury to look at the case and look at it from the point of being a human being and not being some sort of a technician.
Yeah, I mean, I think that's a good point. Of course, though, the jury is instructed, right, to focus on the facts, to focus on the evidence. When you bring up the pictures, we mentioned the picture, you mentioned the picture when the baby is first born, and we know Yesenia Sesmas took that photo, which her friend Laura sent to her, cropped the baby's mother out, and then sent it to her friends and family, passing off baby Sophia as her own. That second picture you mentioned, though, which the prosecution showed again, talked about again in their closings, of the gunshot wound in the victim's forehead, talking about how close the gun had been right up to her forehead when it went off. When the jury sees such graphic evidence like that, such a graphic picture, what effect does it have on their interpretation of the case and the deliberations? I mean, I know in some cases there are pictures that are too graphic. Prosecutors opt not to introduce them because they don't want to, you know, impact the jury negatively.
Right. Well, just showing a picture of a homicide by itself, you know, particularly where the death was a very painful death, or at least the, you know, there's blood splatter and things like that. It can be so graphic that sometimes it can be argued that it's unduly prejudicial. This picture, though, you see the stillness of death, and you see the solitude of death, and you see the loss of a human being, and it's no evidence of any struggle, no evidence of prior knowledge that she was about to die. There's nothing in that picture that suggests that that Laura had any idea that moments before she would be shot that she was going to die. And I think that that's very graphic and very helpful when you're trying to establish that this is a premeditated first-degree murder, because what you're trying to show is that, hey, the victim didn't even know it was going to happen before it happened. And I think that's very powerful in trying to establish the premeditation in this first-degree murder case.
And going back to that premeditation, prosecutors really hitting hard on these text messages that the defendant, Yesenia Sesmas, sent in the days leading up to the murder, right? She was living in Dallas. The victim in this case, Laura Abarca, living in Kansas. The two had known each other for several years. They used to work together. After baby Sophia is born, Yesenia says, I'm going to come visit you. But then the prosecution, in their closings and in their rebuttal, brings up these text messages she sent, sort of fishing for information in the days before. What day does your fiance go to work? What time does he leave? Will you be alone? Is there any security? Or I'll keep you company when you're alone. And the prosecution really hammering home that just these text messages prove premeditation. Do you agree?
Very much so. Let's look back what the defense made it as their argument in their closing. Again, I think they did. I mean, look, sometimes you just get really bad facts, and you know, it's an old joke. If you have lemons, try to make lemonade. Well, this is sour lemons. You've got nothing that you can do with this case. You're just trying to show some technical arguments you can make. But let's look at what the defense argued. They talked about careless and reckless behavior. They talked about unplanned and spontaneous behavior. They talked about faking a robbery and kidnapping, but not intentional murder. And they don't really back it up with actually any facts. They're just sort of throwing these words out and then hoping that the jury, when it goes back to deliberate, will sort of, what about this? Could we possibly make an argument this is something other than premeditation? I think you need to lead the jury down a path by showing them at least where the door is so they can sort of walk down that hallway if that's the direction you think they're actually going to go. And the problem is when you try to add any facts to the case, the defense basically sort of says, well, it could be this, it could be that, and that would be something other than premeditated first-degree murder. But they don't, you don't prime the pump. You got to kind of give them some facts that they can sort of go in that direction. And again, the lack of good planning doesn't mean the absence of planning. And I think that's what the jury is going to be most struck with, is that there was planning here. Bringing a gun to a murder by itself may not necessarily establish a premeditated murder, but it sure as heck doesn't help. And when you add that to the fact that you're showing up at a house where you have reason to believe that the victim's going to be alone, and you've started to establish sort of this pattern of lies, and then, of course, again, we look at the conduct of the defendant, Yesenia, when she's being questioned by police. So we have the before the murder, we have the murder itself, and then we sort of have what happens after the murder. And what we see is what I think you well said, which is a web of lies. And that is very problematic for a defense, because when you have consciousness of guilt and you sort of have to acknowledge there's deception, basically what you have to sort of acknowledge is you really don't have to regard much of what the defense has to say factually, because, some of it's going to be just plain dishonest. And that is a major benefit in any prosecution.
Good analysis there, Gary. For those who are just joining us, the jury is now officially deliberating on murder charges for Yesenia Sesmas. That is out of Wichita, Kansas. Again, if you are just joining us, Yesenia Sesmas charged with murdering Laura Abarca and stealing Abarca's baby, Sophia, then abducting the baby, taking her to Dallas, trying to pass that baby off as her own. Again, the judge just sending the jury to deliberate. We are going to have much more on this case. Gary and I will be analyzing it further, but we do want to take a quick break to bring in today's top crime stories. Welcome back to the Law and Crime Trial Network. I'm Stacey Delikat. Those were today's top crime stories. The other big trial we have been covering, of course, is that of Yesenia Sesmas. She is the woman accused of murdering another woman, stealing that woman's baby, kidnapping the baby, and trying to pass that baby Sophia, off as her own. Just a few minutes ago, the judge officially sent the jury to deliberate on these charges. We listened to the closing arguments, to the rebuttal. Gary, I am joined, my guest, Gary Gerstenfield, is live with us. He's a criminal defense attorney, and he is Skyping with us from Maryland. Gary was here with us as we watched those closings. So, Gary, I have to ask you, now that the judge has sent the jury to deliberate, we heard the entire closing, we heard the rebuttal. I know it's hard to predict these things, but do you think the jury will deliberate for a long time, or do you think this will be pretty quick?
The tea leaves on that about how much time it takes. So, as a defense attorney, I always think the longer the jury deliberates, the better for my client. And the reason why is because they're opening doors, they're walking down paths, they're thinking about the possibility of reasonable doubt. And you try to create those elements, if you will, like you're planting little kernels of corn and you're hoping they'll take root and sprout and create something. And so the longer the jury takes to deliberate, the more opportunity those ideas take to actually grow and create opportunities for what we call reasonable doubt, which would ultimately mean for the prosecution a defense win. So the shorter for a trial, typically the better for the prosecutor. In this case, the things that the prosecution needs to establish are largely done. We have a homicide, there's no question about it. We know we have identity, that's not an issue. We have a clear victim. Many of the charges, we certainly have abduction and kidnapping. We certainly have that. We have assault. We have so many things that are already conceded by the defense and not really defendable. So really all we have for the jury to really think about is whether this constitutes a deliberative act. Was this a planned murder? And certainly the prosecution, I think, has provided a plethora of information to give the jury sort of enough to find that. And again, not a criticism of the defense, because again, they just got bad facts. And I do believe that the defense did a reasonably good job of trying to come up with something to defeat the jury, rather than just stand there and say, come on, guys, do something good here for me, or, for my client. So is it going to take a long time for a verdict? I don't think so. I suspect we'll have a verdict in somewhere between 2 and 3 hours.
Well, and a little tidbit of information I just got from the ground in Kansas is that the jury, they're actually bringing in pizza for them. They have requested to work through lunch. So that says the jury wants to get right to work and doesn't want to drag this out.
Yeah, I'm not surprised.
Gary, one last question before we revisit some of these closings. As a criminal defense attorney, if you were Yesenia Sesmas' defense attorney in this case, what might you have done differently? Would you have put witnesses on the stand and put on a case yourself?
Well, the problem here is trying to find witnesses that are going to be helpful. From what I've seen in the trial, there really isn't. A comment that you made earlier. So the problem is, if you try to put on any kind of defense witness, you run the risk of those statements being very inconsistent and sort of pushing the envelope, or pushing this idea that Yesenia is just a plain liar. Again, more consciousness of guilt. So there's really not a lot of witnesses that she can produce. And again, would I do differently with this? This is a really tough case as a defense attorney. And again, sometimes you take really bad cases to trial because you're hoping for possibly some appealable error made by the court justifying a new trial. And sometimes that happens. I've had cases where they were absolute dogs, but the prosecutor was a little overzealous and got evidence in over my objection, and it turned into a reversible error. And we were able to get a much better deal the second time around that we would have ever gotten had we not taken the case to trial. I'm not saying that's going to happen in this case, but that's a risk that you run as a prosecutor, particularly when you have such strong and compelling evidence. But they did a very good job, very methodical. They took their time. They dotted their I's, they crossed their T's. Watching this trial, I did not see any reversible errors, certainly from my vantage point.
Well, that's a good point you bring up, though. The defense is probably always thinking about where can you find those holes or there's lapses where you could, possibly, I guess, as you say, get the case dismissed, appeal it, so on and so forth. Again, if you're just joining us, the jury has been sent to deliberate in the murder case against Yesenia Sesmas, the woman charged with killing Laura Abarca and stealing her baby. From what we're seeing, right, Gary, we think that this could be a somewhat quick deliberation, or we know at least that the jury wants to get to work because they have asked for lunch to be ordered in. They did not want to take any breaks. We are going to be replaying some of the closing arguments for those who are just joining us now. Again, we did hear the closings in the last hour and a half or so. Of course, the prosecutors, really trying to hammer home this point that this was a premeditated murder. The defense saying it was reckless, it was not intentional. As you said before, Gary, this really isn't a case of whodunit. We know the defense has conceded to a lot of these crimes. But before I let you go, Gary, what do you think, let me say it this way. What do we think in terms of the defendant here? I want to bring up one thing, which was that last week they actually had to put court on hold. There was a little recess because she had chest pain, she had anxiety, she, had to be hospitalized, then she was brought back in. Does that play any role in the jurors' minds, in your opinion?
In terms of what they have to decide, no. This is not, okay, clearly I think it's a fair statement that Yesenia has some sort of major flaw as far as, in the humanity category. And so one of the questions that, as a defense attorney, you have to look at is, gee, I wonder if my client's possibly crazy and not criminally responsible because they've got some sort of mental illness. Unfortunately, being just an evil person or being somebody that's just sociopathic does not meet the standard of being crazy.
And she was found fit to stand trial. We know that.
Oh, yeah. Yeah. I mean, I think it's a fair statement that she's, it's a horrific crime. And it's a fair statement to make that, she's really just a horrible, horrible person.
Well, and look, as we know from the testimony, she told detectives when they asked her, would you do this again? She said no. So I'm sure she probably has a lot of regrets about what happened on that November day back in 2016. Gary, thanks so much for being with us to discuss this case and analyze these closing arguments as we wait for the jury to come back from deliberations. Again, for those who are just joining us, the jury is now deliberating murder charges against Yesenia Sesmas, who is charged with murder and kidnapping a young baby girl, trying to pass that baby off as her own. In case you missed those closing arguments, we're going to go back and revisit them now, starting with the prosecution.